candle, get lit, you listen in the mail. Light the candle, let the truth prevail. Pull up to the show with mail. Subscribe, share, comment below. Candlelight and confessions with mail. Face knock loud, let the whole world tell. Real talk live with mail. Subscribe, share, comment below. Candlelight and confessions with mail.
This is Candlelight and Confession, where the truth comes out, whether people like it or not. Go ahead and pour your drink because we're not sugarcoating anything. If you've been here before, you already know how we do it. If you're new, welcome. We dealing we dealing with facts, we dealing with receipts, and yes, we dealing real opinions. And don't forget, respect the space, but speak your mind. Welcome to Candlelight and Confession. And I am your girl Mel. Let's get started. Let's get started what we stopped on last time. We talked about the motion that Ari put in to get Quadajah released with the appellate court. We also went over what the appellate court requests back from the defense team. They stated, well, we need all the evidence, everything, whether it was records, exhibits, whatever it was, we needed. Okay. And so that's where we stopped off at. And she had until March 25th to get that information to the appellate court. Now, since then, state, the state had responded to Ari motion. Okay. So that's where we're going to start today. We're going to start with the state. Now, it's at 18 pages. I'm not going to go over all the 18 pages. I read them all. I don't feel there's need to read it again. I'm just going to go over um, pretty much what it states and what is expected and what's happening now. Okay. Um, there's a few things happen after the state responded, and we're going to go over that as well. So I just want to show you the documents, the 18 pages. Like I said, I'm not going to read over it, but let's see here. Let me bring it on the screen. Okay, so this is as you can see, they filed it April 1st, 2026, not too long ago. The state did. And again, it's like 18 pages or so. Um, Pretty much detailing what their verse side of what happened and what the witness said, which is not too far off from what Ari put on there as well. So that's why I feel like I read hers. I'm just feel like it's not necessary to read all this. Um, so let's talk about it. All right, so we got, let's see here. We're gonna start off with the beginning, okay? Just to get caught up for some people that have not been following. Just a quick recap, okay? Let's go all the way back. The defense represented Quadajah Johnson, aka Holly Johnson, filed an appeal asking one main thing: let her out of jail before the trial. And this is called the Rule 604H appeal. And it specifically challenges the judge's decision to deny pretrial release. Okay. So the defendant argued that the defense filing, there was a history of threats. Okay. So they say Romeca made history of threats towards Holly. Holly even tried to get a protection order. The victim allegedly ran up on her first, which they said Romeca ran up on Holly, allegedly first. A 911 caller even says she seems to be the aggressor. but the woman in green has the gun. Now, it says she seems to be the aggressor, but the woman in green has a gun. I don't know who she is. We don't know who she is because we can't assume she's talking about Romeca because they wasn't the only ones on the scene. Okay, because you had witness one, which is Carlo. They could have may have thought because the long hair he was a she. I don't know. I'm just saying we don't know who she is. Okay, and most importantly, they are building a self defense narrative. Okay, so that's the defense team. Now they saying to the judge she shouldn't be sitting in jail because this wasn't murder. This was protection. Okay? That's their defense. So then the state claps back with just that 18-page form I showed you. And pretty much what they said is, let me tell you, let me just say this. Now, here comes the state, and baby, they didn't play. Okay? Now, this is from the state's response. They said, Quadajah is charged with first degree murder. The judge already ruled detention was justified. And most importantly, the state does not have to prove self defense right now. This is not what it's about. It's not about self defense. It's about whether she is better behind bars or out in the public. Okay? At the detention hearing, the state only has to prove the crime likely happened, which we know it did. Quadajah Johnson, aka Holly. Holly is a danger. Well, we know that allegedly she shot Romeca because of an argument, not because Romeca had a weapon, not because Romeca was beating her. None of that. Nobody said that. They had an argument and she shot her. So, yeah, I consider she's dangerous, in my opinion. But let's continue. No conditions can make Quadajah Johnson, aka Holly, safe to release. And it's not about her being innocent or not. It's about is the public safe with her on the streets? And I think not. And that's just my opinion. Okay. Now, the state's strongest argument. They said even Holly claims self defense. They saying even if Holly claims self defense, that's for trial, not now. Again, they do not have to prove self defense right now. Okay? That's not what it's about. Now, the state also stated that the victim, which is Romeca, was unarmed. Romeca was not aggressive. They said the defendant, which is Holly, defended Holly, the one advancing towards Romeca. Holly retrieved a gun and Holly fired multiple shots. And then the state said even threatened to shoot. Holly even threatened to shoot before shooting. What? Let me read that again. They claim she even threatened to shoot before shooting. Oh, we got to drop the mic on that. That made, she said, I'll shoot you, and went to get the gun and came back and shot her and did exactly what she said she was going to do. That ain't self defense because if you made it to that car, you could have made it home. Okay. Oh, wow. Okay. So then it says the state narrative this wasn't survival, this was escalation. This is what the state said. They said wasn't survival, this was escalation. Now, they also told the court And this where everything get a little messy. They said that the defense did not include the video evidence in the appeal. And that's big because appellate courts rely on the record. If it's not in a record, the court acts like it doesn't exist. In other words, if it's not part of the record, we don't know nothing about it. It don't get looked at. Okay? That's what they're saying. Now we're gonna back a little bit and kind of show you. So the defense claimed there was no record of the video that she submitted to the appellate court. Now, the appellate court jumps in and it's like, hold on, something's missing here from the motion timeline. So the court ordered the defense to submit all exhibits, including video. Okay. And remember, we talked about that. That was back in March. She had to the 25th to get all that in. And here's the twist the defense responds, we did submit the evidence via flash drive. Okay. So in that motion, state said she didn't give the video, it wasn't attached. The defense came back and said, we did submit the video evidence via flash drive. So now we have a conflict. State said no video. Defense said yes video. Court said send everything again. Okay. That was those three things. But come to find out, and let me go back here and again. Let's see. I'm gonna bring this up here again, just to show you what I'm talking about here. Kind of make it go quickly. Okay. So what I was just reading, this is what we're talking about. This was state response, right? This was when the court sent the defense team saying, "Hey, we need more information before we can rule on this." Okay, and you got into March 25th, 2026, to send us all the information. Okay, whether it any video exhibits or made available in case center upon receipt by the court, the submitted record will be treated as having been filed with or leave of court. Okay, so that's where that came in. That's the argument. So then Ari came and put in another motion, and she pretty much went for the timeline, saying on December 3rd, Johnson was arrested for the offense of first degree murder. On December 4th, the detention hearing was held for Ms. Johnson in trial court order. It went all the way down, just telling where we are today. And so she said on March 23rd, the impounded exhibits were provided for defendant appellate to review VI case center. On April 1st, 2026, the state filed appeal remandum please response to the defendant appeal for ordering denying pretrial release. The appellate court of Illinois' first judicial district ordering and ruling on this matter is scheduled to be filed by April 20th. So, but before then, she said such exhibits was delivered at the clerk of the circuit county on March 20 via flash drive. So this is where she's saying she gave all the information. Whether it was a video attached to it, I don't know because it's not listed exactly what she gave. But it's saying that she delivered all the exhibits via flash drive on March 20th. Okay. And then she went on to file a motion to the state saying, hey, the state got some information misconstrued. We want to clear this up. So please give us the last voice. We need to respond to state response. Okay. And that's what she did. She sent that in. And then yesterday, which was Saturday the 4th, as you can see, Saturday, April 3rd, as you can see, they granted to give her the last word. She got until 5 p.m. April 7th to submit. Okay. So that's where it is right now as of today. All right. So let's go back and kind of talk about some more stuff that state had in their response. Okay. Um, because right now it's like a back and forth thing here. Okay. So let's see here. So here's the twist. The defense respond, we did submit the evidence via flash drive, like I just showed you, and now they have a conflict again. State said no video. Defense said yes, there is video. Because both sides are technical speaking from different versions of the record. Defense fights back. Now the defense says we need to reply to the state's accusation, so they filed a motion asking permission to respond, which I just showed you, and it specifically say the state made claims that need to be corrected, clarified, or challenged. They claim the video was missing. The court decision on or reply, the court had to decide we will allow the defense to respond again. And I also want to show you something that caught my attention on that. Uh, Let me bring that back up here. Where she said, here, where it's high yellow, where I got it high yellow, highlighted in yellow. It says the reply is due on or before the 5 p.m. on April 7, 2026, and petitioner appellant should note, saying they should note that this court is aware that video evidence was made part of the record. So that's what they're saying. We already know that the evidence was made part of that record. Okay? That's what they're saying. And so it becomes critical now. This is where it becomes very critical. So by them gonna let her respond, it's critical because if the defense is allowed to respond, which she is, defense defense get to fix the narrative. And what that means is let's bring it all together, okay? So this is the battle that's happening right now. It's not about guilt yet. It's all about should she stay in jail while waiting for trial. Now, here's the state point, okay? So we playing with two competing stories here, the state and the defense, okay? Now, the state says highly escalated the situation. They said Romeca was unarmed. They said Holly retrieved the gun. Holly fired multiple times. Holly is danger. They just saying she is dangerous. Okay? That's the state. Now, on the other side, the defense is saying the victim had a history of threats, which talking about Holly had a history of threats. Holly approached, no, they say Romeca is the victim. Romeca had a history of threats. Romeca approached first. The situation turned physical. Holly feared for her life, and the video supports her claim. That's what the defense is arguing. Now, I'm going to ask you who looks more believable right now? Not forever, just enough to decide whether she should be relieved from jail or stay in jail. Just that part only. Put on your thinking caps. What do you think? Do you think she just, what do you think? Is there enough evidence to keep her behind bars? Or are they going to let her go? Because I'm going to tell you like this, the lower court, the judge, he saw that video Ari's talking about, and he decided with the state. But the appellate fight is about interpretation and missing video in the record. That's where we stand right now. Because the appellate court, even though they said they know there's a video that's part of the case, but they're not saying we seen it or we have it. That's not what they said. They just said they just told Ari, hey, be aware that we know there's a video. That's all they saying. Not to say, because they said she didn't send it. Ari said she did send it. So we'll find out sooner or later. And this right here is why the case is so divided. Because depending on which version you believe, this is either self defense or calculated escalation. But one thing is clear, the fight isn't over in the courtroom, it just got started. And when the video finally becomes clear, that's when everything's going to change. And it's not going to be about
It was unbelievable, but I was there.
it's not going to be about
Hey, I got a CCL and a restraining order.
it's going to be about just like that. Another confession hits the table. Some of you agree with, some of you may haven't or didn't. But one thing for sure, we talked about it because the truth doesn't always feel good, but it's always deserved to be heard. And tonight, we said what we needed to say. And if you haven't already, go ahead and like, comment, and subscribe and drop your thoughts in the comments because I do read them. Y'all be having a lot to say, and I love that. This has been Candlelight Confession, where we talk and we speak the truth and we don't sugarcoat. Until next time, keep your drinks poured and your eyes open.
True life. Real talk nights where the truth gets told. Stories so real, make the whole world scroll. No fake vibes, yeah, the energy real. When the candle get lit, you listen in the mail. Light the candle, let the truth prevail. Pull up to the show with mail. Subscribe, share, comment below. Candlelight and confessions with mail.